that are put together for the benefit of individual creative practitioners. So it's really focused around supporting artists and creatives in understanding more about the sort of business of being an artist. So this is the third conversation in our series to talk about contracts. And these, I guess, are things that we have to deal with as part of throughout our careers as creative practitioners, and ultimately part of any kind of negotiation that you'll have with an organisation to present your work will involve a contract. And, you know, in the getting of grants from Create New South Wales, that will involve a contract too. So it can be a bit tempting sometimes because the legalese can sometimes be challenging to not read the fine print and to just sign on the dotted line. So this episode should really be called Don't Just Sign on the Dotted Line. And we have a fantastic speaker today to take us through some of these issues, who is Sally Hanson, who is Acting Deputy General Counsel, Arts and Tourism, Legal and Corporate Services for New South Wales Government. And also on board today is Yanni Clark, who is actually Acting Manager in Arts Strategy Engagement, and Ros Richardson, who is a Senior Advisor in Media for the Department of Creative Industries, Tourism, Hospitality and Sport, which is what Create New South Wales is a part of. So they will help us to navigate your questions during this webinar, and we're really grateful to have Sally with us tonight. So Sally is a senior lawyer. She has over 3 decades of experience working in areas of law that relate to arts and culture practice, and particularly in the screen industry and in copyright and intellectual property. She's held senior roles at many organisations that are too many and varied to list, but so we're very grateful that she is working with us at the moment, and is someone that we can actually talk with and draw from her immense experience in this area. And so I am going to now just run the slide presentation. Sally is going to deliver this wonderful workshop, and please just feel free at any time to ask questions as she takes us through it. Over to you, Sally.
Thanks, Beck. Beck's now going to drive. Thank you. Beck raised a really good point at the start that I was about to say as well, and that Sign on the Dotted Line is an interesting title for what we're talking about this evening. We could have put a question mark or maybe 2 or 3 question marks after Sign on the Dotted Line, and we're going to talk about a lot of things that we say would be very advisable for all of you guys to do or think about before you get to that stage. So in a way, the title is a query at the end, and we're going to come to the end. You'll see there's tips at the end as well. So it was bookending it quite nicely. And can we go to the next slide, Beck? So as Beck said, we're talking about contracts, and we're going to talk about lots of different aspects of contracts, and we're going to start with the basic sort of principles about what are we talking about? What is a contract? A contract in itself is a sort of old-fashioned word, a legalese word in a way. There's a clue in the picture. There's a clue in people coming together. There's a clue in hands meeting. We sort of talk about minds meeting as well. So that's a start to understanding what we're talking about. And then as we go to the next slide, we'll start to explore this a little bit more. We'll just wait for that. I like to think of a contract as a story, and I understand in this series of episodes we've talked about stories before. Contracts are a kind of story, and they're technical stories, so they're written in a particular way often. But the importance is there's often a beginning, middle, and an end, just as there is often with artwork, although not all artwork finishes at a certain point. There's often iterations afterwards, I know, but it has that sort of structure. It has a language. There are characters in the story. There's actions happening in the story. And it's important that you understand the story from beginning to an end. So that is one way to think about what we're talking about. And Beck, the next one. Another way is to think about contracting and contracts as a relationship. So it's a business relationship, but you're dealing with people and you're dealing with creative endeavours, and you need to be able to work and understand what people are going to do to sort of dramatise, enact this story to the end. And next slide, Beck. So if we go to the law and the more formal definition or the more formal understanding of a contract, we're talking about a legally binding agreement. There's lots of agreements or understandings that people enter into day to day. You may offer to pay your kids some pocket money. Say, this is probably getting old-fashioned now. Is that a legally binding agreement? No. So we're talking about the kind of agreement that the law will enforce and hold people to. And that's important to know because there are serious consequences once you sign on the dotted line. And that's why we want to do all this work first, this teasing out of what exactly you're signing and why it matters that you understand the story. Now, in terms of a contract and a legally binding agreement, you usually have that between two or more people or two or more organisations. So you may have not-for-profit organisations, you may have commercial organisations, you may be dealing with the state government with funding agreements, but it's usually a person or their business and someone else. So that's usually what we're talking about. Next slide, Beck. So where does this law come from? Now, that's the Bayeux Tapestry, in case anyone's wondering why I put that in there. And the law is actually very, very old. And this explains why some of the words used in it, what Beck called legalese, that we try to get away from now. We talk about writing in plain English, which is actually probably like good English. So that's the endeavour now for lawyers. But we don't always succeed, I suppose. So the law is actually very, very old. There's some people say it really started from Norman conquest in 1066 in England, so it does come from England, our law, and then it's imported in the Western law. We'll mention ICIP a little bit later. But the law that the courts are going to enforce is Western English law. Starting off at that time, but really, and the next slide, being developed from the early 1500s, so very, very old concepts. And we talk about it being English common law. That means it's law that is made up really by judges as opposed to Parliament. Now, over time, Parliament has come in and said, we don't want to have these unfair contracts for interest. We're going to protect consumers. So there is some legislation, and that's like an overlay. But the basic principles are very old and in a way that very simple. There was this idea of a freedom of contract. It was people coming together and doing a deal. And if it was a deal and it was business and it wasn't things like pocket money or gifts, it had certain elements, you would be caught then with the deal and you have to comply, you have to perform your side, each side of the bargain. So hopefully that makes sense, yeah? So next slide, Beck. This is where I'm talking about it's a choice. So it's different from, say, criminal law where the state says these things are wrong. And if you do these things, you may be charged with an offence and the state will impose penalties on you. Contracts are thought of as if you've got a choice to do this, and this will be sort of relevant to you when you think about, do I want to do this deal? Is this good for my business? Is this good for my art? You know, will this achieve what I want to achieve? So it's something, again, to think about when you're looking at a contract, when you're looking at the story. Is this something I want to do? Is this someone I want to work with? And the courts and the law understand that principle. And what they often say is, well, look, you've chosen to do it. And yes, there's some elements where we might say that's unfair and you don't have to. Mostly, if you sign a written document, mostly that's it. So again, that's important to understand. Next slide, Beck. Okay, so that was the sort of first bit on, I don't know whether anyone's got questions on that, but the first bit on what are we talking about. And now we're going to dive deeper into contracts and the sorts of documents or other communication you might receive and how we as lawyers think about them. So we're talking about contract types. And again, this matters if you're dealing with government or other people to understand the language and not be sort of afraid of the legalese or the language. Just see it as another way of writing, another way of speaking. Yeah. So next slide, Beck. There are two main types of contracts. And I've called one, we've talked about agreement before, so I'm talking about the binding agreements, and they're often called simple agreements, and we'll get to them in a minute. And then there's deeds. And actually, governments can often use funding deeds, and I've mentioned that. So often and deeds are seen as special, and they've got special rules. They're the two main kinds, and there's some slight differences between them. And then underneath that, I've got some words that you might see when you're doing deals, depending on the kind of artistic endeavour you're involved in. So you might see term sheets or deal terms. Now, in the screen industry, say, they might be with broadcasters, for instance. So they might be with distributors. And they're like a short form summary of the basic terms, the basic things, promises, but they're going to be fleshed out a bit later. Or you might get like a heads of agreement. Okay, these are the top level things we're going to talk about and agree on. Or letters of intent. You know, I'm interested in supporting you. I'm intending to give you some money. I'm intending you to be able to use this space. An MOU is a memorandum of understanding. So memorandum a bit formal, but an MOU is the short form of that. Those sorts of documents may or may not be binding. They may be, let's just get the top level things down, but you need to be careful and get advice if you need to about whether that locks the other person into actually doing what they're saying they're doing. Yeah, so we've got simple agreements with rules, deeds, special rules, categories of other things that may or may not get you a deal, but are starting you on the road to a deal. And you need to understand all of those things. Okay,
Can I ask a question before we go to the next slide?
Yes.
Just on how people might receive, and you might go into this, Sally, so do tell me if you're getting to that. But if someone receives an email that says, I'd like you to undertake this webinar for me,
yes,
for a particular fee at a particular date and time, would that be counted as a kind of a agreement?
Yes, so it can be, and I do get into that.
Okay.
Yes.
Well, let me not hijack your approach.
But it's a really good point, you know, because and I'll just flesh it out, and then we will flesh it out a bit more. But it's a really good point that you may not be looking at something as formal as, say, in that picture, with some formal writing by the side, that you're not necessarily looking at, you know, a hardcover with a spine and everything nicely written out neatly. And it says, you know, it's a sort of formal legal agreement. So you do have to be careful. Catching a bus is an agreement to catch a bus. So clicking on websites, and you know when it says, you know, click on I agree. People make contracts that are real all the time in daily life. And they make them, and we all make them, in all sorts of different ways. Yeah, not just formal ways. So I get to that in a minute. So next slide. So we'll get to it soon. These though, I'll just do this first and then we'll get to the formal part, the form part of it. So what do you need to have something that the court will say, I will hold you to this and I will hold the other side to this? You need 4 elements in a simple agreement, you need 4. One is and I'll talk about the language because particularly if there's disputes about things and lawyers are involved, they will talk about the formal language. So formally, you need an offer. So I'm offering you the chance to do a webinar on Monday night, right? An offer. And then you need an acceptance of that offer, right? So I have to say, I will accept doing the webinar on Monday night. Now I've got there a counter offer. If I say, oh, actually, I'd really like to do the seminar on Friday night, it doesn't match the offer, right? So we talk about a counter offer. So if someone said to you, will you paint my portrait? And you say, I don't feel like I want to paint your portrait, but what if I paint your dog's portrait? That's different, right? So what happens is the first offer to paint. So what if the other person says, oh, I don't want a portrait of my dog. I want to go back to me, right? You've sort of lost the chance of saying, I accept that, if that makes sense. So the offer, the acceptance has to be an acceptance of that offer. When you say, no, I've got a different idea, that's you offering something that they can accept or reject. And some people sort of don't understand that you then, unless they want to agree, you can't go back and say, oh, forget I said that. So that's that. You need an exchange. And what that means is in legal terms, that's called consideration, which is very old fashioned. But what it sort of means is it's not like a gift or free. The exchange doesn't have to be like equal dollars to the value, but each side has to do something, right? So it's a bargain. And that's when, when I had the HADS class, it's a bargain, the meeting of the two people, two organisations, a person, organisation, but making a bargain and exchanging something. And then, this is the pocket money, the intention to be legally bound. If you offer your kids pocket money, you don't want to be sued in a court, right? That's no intention of your child standing up there saying, I get $10 a week. It's probably more than that now. So that intention to be legally bound, right? Not just giving a gift or having a chat or being nice to someone, you need that as well. Now, if you can show those 4 elements, if you tick them off, right, you've got a binding contract. There's other things we need to tick off, but they're the core, right? The core things, and you've got a binding agreement, a contract. So the picture is about exchange. Remember, you've got to have that exchange. Next slide, Beck. So what about a deed? A deed is slightly different. And as I said, often funding agreements are in the form of a deed. So what are the differences? You can just have one. We call, like, the people involved, lawyers call parties. So that's another language to learn. It'd be one party and another party. In the old-fashioned, decades ago, you'd say that the party of the first part, the party of the second part, which is, dreadful, really. But it's still called parties. So you can have one. So if someone wants to change their name, we've probably all heard of deed polls, changing a name by deed poll. That just means one person signs and decide something. So you don't need 2 or more. You don't have to have consideration or an exchange in a deed for that to be binding. It's binding sort of when when you sign it, and that can be important because an agreement, so you sort of need everyone to sign and agree. So be sure when you're signing the deed that you're ready to go ahead. And there's certain formal things. Now, some of the formal things, especially after COVID, changed. So unfortunately for baby calves, deeds used to be on vellum, which is a bit, makes me feel a bit queasy, paper or parchment. And if they weren't valid. But now we can have electronic deeds, which is a bit late, really, seeing that was decided from COVID times when everyone was saying, what do we do? So that you need to be in writing. The execution is slightly different. You often see signed, sealed, and delivered, like the song. So that comes from what the law often requires. And a witness is often required. Why I'm saying often is the complexities with law in Australia is we're a federation. So, and as everyone sees with elections and other things, the states are quite different. So they often like to make slightly different rules, which makes things a bit complicated. But so I'm talking about New South Wales, witnessing, and then there's this concept of delivering the deed. Again, a very old-fashioned concept, but basically signing, and it's in front of a witness and it's in writing, which can be electronic. The old days, of course, you did have to have a seal, the old wax seal, and some companies still use seals, so you might see that. Particularly if you're dealing with an overseas company, if what your art practice starts, is working internationally, and of course people are working internationally, depending on where you're working, you might see the seal more than we see it here nowadays. So it hasn't quite gone, it's gone for individuals, but not quite gone for companies. So next slide, Beck. And so they're the things we're talking about, what you need. What don't you need? So what's not going to be a contract? So, and by not being a contract, we mean the court is going to say, we're not looking at this, doesn't qualify, right? So an agreement to agree, the sort of subject to contract, right? An agreement to agree, the court's going to say, well, actually, guys, you're going to have to agree. So go and talk about it. Something illegal, which is probably obvious. Children are in a different, but children, that can matter because children, of course, are creators and are artists. So sometimes their parents have to sign for them, or if anyone is a parent in the audience with creative children, you may be aware of that. So it comes up more often than you might think. So I've got mental capacity. That sort of means if people are really drunk too, sometimes you just got to wait. And if things are missing, like, I said those 4 things for a contract. So if it's an ordinary agreement, it's not a deed, you need that exchange, that bargain. If there's no consideration, it doesn't work, right? If there's no intention to actually have something formal, enforceable, the court will enforce, then that's not going to be a contract either. Okay, so that's that part. And should I pause there for a minute? So we are getting to your question. Yeah.
Yeah, we do have a question that is kind of a bit further down the chain, I think, of information that you're going to bring up. But I do feel like my question about, the email kind of trail that you can bring together to sort of cobble and you actually do have a situation where there's an agreement within that exchange. If you say, will you do this, and someone writes back yes and offers you some money and you say yes, and there you can sort of imagine that there's in good faith that this is binding.
So actually it's on the next slide, I think, because the contract ID is, we're searching for contracts now, everyone, so we're going to have a search. And sometimes lawyers actually have to look and see and have a real search of things. So exactly what Beck is talking about, which is, okay, how do we identify one? What does it look like? What sort of thing is it? Does it have to be in writing? Not necessarily. Does it have to be in a formal book type format? Can it be in emails? Yes, absolutely. It can be in emails and an exchange of emails. Can be in order forms, can be as a website, click through, totally electronic. It can be on baby calf skin. So in terms of writing, it can be in writing and it can be in all sorts of writing, and it can be, as Beck is suggesting, in a number of pieces of writing. So a string of emails, right? So it might be a Word document that's sent with an email, and then single emails are sent. So it can be a combination of things. Can be in conversations. So we'll put aside the deed for a minute. You can have a contract through conversations. And sometimes people aren't aware of how serious that can be. It can be your conduct that actually says that you've, say, accepted something. Maybe someone's put an offer in an email. So what if Beck said, would you do a seminar on Monday night called Sign on the Dotted Line? And I didn't answer Beck's email, but I turn up and do it, right? That's accepting by conduct. And it's, so which is fairly obvious, but sometimes people don't see that combination. So actions, and when I've got at the end combination, it can be all of those things. So, you might have a phone call and then you might follow it up in an email. And you might have more conversations, and then you might send a Word document, and then you might start doing things. You might start working on someone says, would you actually start working on this piece of public art, or start doing a design concept artwork for something, and then you start doing it, right? So it's not as simple as looking for something that says contract up the top or agreement or deed up the top. So next slide. So again, what does contracts look like? Well, it absolutely depends. Depends on whether it's a simple agreement or a deed. It depends on your relationship. It depends on how you've been working together. And that can make it a bit tricky. And then the next slide is that sometimes they're quite formal. And when they're formal, lawyers who are not great creative writers, I have to say, often do them in a particular way. But that can be useful for creative people because you tend to find things in roughly the same places or called roughly the same thing. So see it as signposts and technical writing, not as good as your writing, but an attempt to write this story. And I thought it would be useful to go through what is a common order when you've got a formal agreement. And of course, if you've got a funding contract with government or other places, it will be in a formal agreement. So sometimes, but commonly, you'll have a date. This is the date, and it'll often be the date that everyone signs. This is when we're actually starting, right? The parties will be the people engaged in the business relationship on one side or the other. If it's an agreement, you're going to have at least two, and you can have more. Then there's often a section that is nowadays usually called background, and it used to be called recitals, which is again very old-fashioned, and it's usually A, B, C, D, because I said lawyers are not so good at creative writing, so they tend to follow that. And so background was a very big step to move from recitals to that. But that is supposed to set the scene. So it tells you a little bit about the story. Doesn't really say who's doing what in detail, but gives you often a why. Why are we doing this? Who are we? So it can be good. It sets the scene. And then often you get something that says operative part nowadays. And then there's a whole lot of what we call clauses. So we call the paragraphs in contracts clauses. So the operative part, it used to have often a sentence saying now this deed with witnesses and or the covenants and promises hereafter, like shocking language. So hopefully more and more will just have operative part. But what that means is, okay, we've given you the little story, that a court might have a look at, but below here, this is the guts of it. This is what you are promising to do and what everyone else is promising to do, right? And we're going to hold you to it. If this contract is one of those that the court will enforce, will treat as valid, then this is what you're going to be held to. There can be schedules, and often the schedules have factual information. So again, in grant agreements, you'll often have, well, what is the activity or a creative contract? What creative activity are you involved in? What timelines? And we'll get to this in a minute. What do you have to deliver? The sort of factual parts. And often it's in tables to make it easier to look at and to track the sort of factual part of the deal you're making. Then towards the end, you'll have executed as either an agreement or executed as a deed. And that's important for lawyers to be clear about which one it is, because then lawyers have to put in the signing clauses, and they're called execution clauses, but it means where you sign, right? If you're a company, you sign a particular way. If you're an individual, you sign a particular way. Individuals can have marks. I've had individuals who do use a mark and don't sign their name with letters of the alphabet. So there's signing clauses, and then you can have annexures. So say for a screen project, you can have quite a long budget attached, or for other artistic works, you might have a plan attached, a project plan or creative plan attached, or a business plan for the organisation if the business itself is being funded. So they're quite sort of lengthy. They're important documents because you're saying, okay, I'm going to do all these things that I'm promising to do, but they're often attached at the end, so they're called annexures. So that's a sort of typical way that lawyers like to operate, and it gives you signposts or clues, as I said, to look for similar promises in similar places. Okay, so that's that one. Is everyone right so far?
I think we're all good to proceed.
All good? Okay, keep going. I'm trying to make this exciting. It's hard.
I'm finding it thrilling.
So what are we talking about? So now we're deep diving into the story. We're going to read it. We're going to start reading. So what are we reading? We're reading about promises. People are promising all sorts of things, right? In words that might be spoken or written. There's a thumbs up. Thank you. So they're promises, but the promises in law are called terms, and sometimes we call them terms and conditions. And I'm not going to go into it. Sometimes we categorise them in different ways, so I'm not going to go into that detail. But you're talking about promises and terms. So you might have, again, like a term sheet, a promise sheet, a deal sheet, which again shows you that what we're talking about are deals that people are making, right? Now, in law, though, I just wanted to mention that we've got express, and that means the things that are said out loud, which is fairly clear. Now, that might be in writing or over the phone or face to face. And then sometimes there's things that are implied in the document. So that just can be if you hear people saying, well, we mightn't have said it out loud, but you have made this promise even though you haven't read it, and that's because it's customary or trade that that usually happens, or sometimes there's some implied terms because of legislation. So for instance, in consumer contracts there can be some where the courts are trying to make them a bit fairer. So just to say that not everything is necessarily written out and said out loud, but what you do need is certainty. So that's really important. So if someone said, so say Beck said, now I'm not getting $3 for this. So say Beck said, Sally, would you do a seminar, a webinar on Monday night, and I'll give you a reasonable amount. I'll think about the amount, but the amount might be like something like what other people pay for these sorts of things. Well, a court would say, well, that's not very helpful. Like, how can we know what that means at all? And what a court often says is, well, that's not enforceable. We can't enforce anything because we don't know what you mean, right? It's just too uncertain. And so a court will say it's too uncertain, and they talk about void for uncertainty, which sounds all horrifying. So someone can't say to you, I'll think about what I'll pay you and tell you about that, in 10 years' time, right? So apart from that, absolutely not sounding and being fair, it doesn't work, right? Because the law is not, I know, law can be a bit frustrating, but it's not that silly. So think about that. When you're writing the story, doing the deal, make sure it's certain for you, certain for the other side. And that leads to less disputes, leads to less uncertainty, which is better to have everything out and negotiated and work out where you're not exactly on the same page and flesh it out first. And so that's a common sense principle, but it's also a legal principle. And again, it feeds back into if you say it's subject to agreement, subject to contract, well, the court's going to say, well, you're not there yet. Okay, so next slide. And I just thought I'd list some of the agreements that you may or may not be involved with, because I don't know exactly the people in the virtual rooms that we have, but commissioning agreements, so say for new work, loan agreements for existing work, touring agreements, fellowship, internship agreements. Artists enter agreements and have all sorts of business relationships all the time. Collaboration agreements. So commissioning might be someone working by themselves doing a new work, but then there may be collaboration on all sorts of other artistic endeavours. You can work as a contractor, so you might be engaged under a contractor agreement. It might be called a consultancy agreement. You might be an expert in your field, or you may want consultancy services from someone from a different cultural sector, a different background, and they're often used in like First Nations consultants on particular or in particular fields, or in the screen business when you've got elements that involve First Nations intellectual property. CIP. We can have copyright license agreements. Now, the next session, I think, is about copyright. I'm not going to go into detail, but I'm just flagging that as another kind of agreement, and funding agreements, of course. So examples of agreements. And then the next slide will be examples of deeds. So again, don't be, they're just language and words to describe the deal. So funding, you often get funding either as an agreement or as a deed. Now, why that matters to you is that the signing clause is going to be slightly different, right? And once you sign up, you're even sort of stuck with it even before the other party signs. So it's quite formal. Confidentiality, particularly with ideas that artists have, right? So often copyright doesn't protect a single idea or a simple idea. We'll leave what it does protect to next week, but it means that artists, and say you're pitching things, are required or want someone to enter into a confidentiality deed, a deed of termination if you want to actually bring a project to an end, deed of indemnity, I'll talk about indemnities later, or the deed poll idea, which can again be a confidentiality or one-sided. Someone is giving you their confidential information and they want you to promise not to tell anyone about it, to only use it for what you're discussing, right? And they want to be really strict, so they might actually give you an agreement to sign by yourself and call it a deed poll. So this is what some deeds did used to look like, and they were called indentures. And in the old days, they used to indent, like do wavy lines for different copies, and then you could put the deeds together and say they're the same document. So you'll be pleased to know that's gone and it's no longer required. But that is, a real example. So next slide, Beck. Okay, so again, we're thinking about the content, the story, the actual story now. We've looked at the form, the structure, okay? What's it saying? The big thing is why. Think about why you're doing this deal. What do you want to get out of it? What's your purpose, right? That's at the core. And then when you've decided, yeah, I want to do this is a good idea, I know where I'm headed, I know why I want to do this, think about these elements that have been actually raised, I think, in the previous episode. So who are you working with? Is it an individual, an organisation? Is it someone that you feel like you can? Is it a good fit for you? How strong are they? Can they do what they're promising to do? And then what? Who is promising to do what? Okay, are all the promises on your side? Is it a shared promise? Is it clear about who is doing what? Contracts often have really simple sentences. Again, for those creative writers, you'll hate this because passive tense is not used. It's often active voice, and it's like subject, verb. It's just, I will give you this, or, right? So very, very simple structures, but in a way that's good because it says, okay, who is the actor? What are they going to do? Yeah. So they're the essential things. Then how and when. When is important? Can you meet those timelines? What sort of timelines are they? Reasonable or not? Are they fleshed out? Are there milestones? Milestones important because often payments are attached to milestones, right? So milestones is a kind of timing, but also an action. Often you've got to deliver something or do something by a particular time. And then it's always check what it relates to. And then when I talk about duration, because lawyers sort of talk about duration, and I've got term in brackets. This is where some of the legal language is confusing. We use term to mean the promises, and we can sometimes use term to mean how long something lasts. So again, understand the language of your deal and the contract. And then where, the sense of place. Okay. Where for the work? Where are you doing it? Are you doing it on site? You know, what protections do you need on site? Are you doing it in your house? If you're doing it in your house, how are you going to get it to a site if you have to? And who's going to be responsible for that? And what happens if it gets carried and smashed? So once you start thinking about place, you have these other questions, again, sort of common sense, but think about, I better sort that out now because I don't want them coming back and saying, oh, that's your fault, you pay for that, or go and do it, give us another one. So what sounds simple, again, can lead to a number of steps. Yeah. So next slide, which is, again, when we're talking about terms now, meaning the promises. And I'm just going to, again, start with almost some of the headings you see in contracts, or some of the headings you will be discussing if you haven't written it down. And we'll get to the tips, which is write it down at the end. So I've got relationship up the top. Now, often there is what we call a clause, so the paragraph, talking about what is the legal relationship between the people who are doing the deal. But I've got it at the start because you need to think about that. Are you a contractor? Are you an employee? If you're an employee, then you should get all these entitlements as an employee, right? If you're a contractor, you don't get the same entitlements as an employee. You may have to take on some of these, say, insurance or other things, but you still may be entitled to super, so especially if you're a sole trader. So, you know, you've got to think about that sort of relationship. Are you a grant recipient? You know, is it a government organisation, not-profit organisation, other organisation giving you money? So you're not their employee, but you've got promises in that sense. You're a grant recipient. I've got subcontractors there. Are you allowed to actually sub it out? You know, or do you have to do everything yourself? And sometimes if the deal lets you sub it out, there's going to be restrictions on that. You know, the person saying, oh, I'll agree, but I want to approve them, or I want to check them out first, or you've got to come and tell us, do you want to do that? And we'll think about it. So if that's part of the way you operate, you know, you want to manage a project, think about if there's any restrictions on that part of it. So that's why I've put that up the front, because that's like how you frame it, how you're working. Of course, the activity and the work as a creative worker, that's what we're talking about now, arts contracts, what you do. So think about the scope of the work. Are they asking too much or too little? Do you actually want to do more? You know, think about whether you have to revise it, and then why? Just because they don't like it personally? You know, is it a subjective thing? Or is it if there's a mistake or it doesn't meet the brief, you know? And so sometimes if there's a design or artistic work, there's a brief attached. So is it, you know, it doesn't meet this, or is it, well, I've changed my mind? So that's important. How what you do can change. Maybe you want to change it as you actually go through a creative process. Maybe they do. So we talk about, but how does the contract vary? How does the contract express that and let each side change it? Usually you've both got to agree to actually have a change, but sometimes there's process as well, and sometimes who agrees is more one-sided than the other. So you need to sort of think about that. Ownership and use, who owns what? As creative people, you want to mostly own your creative material, right? So think about who owns it. And also, if you're creative, and this is where I mentioned copyright again, copyright ownership can be different from owning the physical thing. So, copyright in the actual artwork on a painting is different from the frame and the canvas and the physical artwork, right? Which is why if you sell a painting to someone through a gallery, you're not selling them the copyright in it, you're selling them the physical thing to hang on a wall. So it's important to look at a contract and say, what am I giving away? Am I actually selling something? Am I giving permission to use something? Am I transferring everything across? Yeah. And is there a difference between the physical stuff, the canvas, and then the creative stuff? Right? Is there a difference?
That's a really great point, and I think there's so many things here, but I'm just drawing from my own experience in working for an organization that had a collection and having to produce a range of postcards from that collection, and then actually having to go into another agreement with the artist that we own the work of in order to request the use of the image from the collection and then to remunerate the artist for that use for that particular purpose. And so it's exactly what you've just talked about. It doesn't, the person having that object doesn't give them the right to spray it all over town.
Yeah. No, that's
Basically.
exactly. Yeah, no, that's a really good example, a sort of live example of this. Yeah. So all these things aren't in theory, like they're actually really often really, really practical, and they are about your rights. And if you are giving permission to use something, what does that look like? Is it so broad that someone can do anything with it? Or not. There've been good examples actually on Instagram, particularly, I think, where people have signed up to conditions, or on various websites where people sign up and don't realize they've given these broad permissions to use, so commercial companies can actually take an image, and the artist had no idea. They thought happy with not-for-profits doing it, but not big corporates, doing it free. So you do need to be really conscious of that. And then I've got copyright with the little C, which we'll talk about next week. And intellectual property is broader than copyright. And that will probably be mentioned next week. But often you'll hear people talking about IP and copyright, and there'll be clauses dealing with IP. So I suppose the first point is IP is broader than that. ICIP, it relates to First Nations, and it still uses the word Indigenous. So, and that's because the term ICIP has been used for decades and has a particular meaning. So at the moment, still using that Indigenous term, whereas mostly we're first talking about First Nations. So it stands for Indigenous Cultural and Intellectual Property. Now, that in itself is not a recognised kind of IP at law, unless it fits into the English Western law, right? So in itself, it's not. But there's lots of protocols around its use. So creators need to be aware of that, and that often contracts will include a clause that says you have to comply with a particular and often a named protocol, and that is trying to make it enforceable. In other words, a court can say you did the wrong thing when it wouldn't otherwise be enforceable. So look at those clauses. So it's giving rights, not necessarily to the owners of the ICIP, giving rights to the other party, but trying to bring in something and give respect and recognition to sort of cultural property that isn't otherwise there. So that's the purpose. Yeah.
Yes, and we do have ICIP in our contracts that Create New South Wales funding. And this is an area that we will look into next week, but we'll also do a standalone ICIP webinar down the track as well.
That's
and
great.
Also Creative Australia have a lot of information on ICIP in our context in arts and culture, and it's very well researched, and they've been doing this for decades, so they've got really great resources around it.
Thanks, Beck. And then I've mentioned moral rights because as creators, depending on your artwork, but as individuals, you will have moral rights in your work. And I've got capital M, capital R, because it's not just a general idea of people being moral and ethical about using a creative piece. It's actually much more, as this typical law really just defines them and says it's three things. So that's it. So it's the right to be named, the right of attribution, the right not to have the wrong name on something. And there've been court cases about, I think that was a new idea, putting the wrong name somewhere. So it does happen, even though it sounds a bit silly. It happens. And then the right of integrity that people might be aware of. So the right to not have your work subject to a derogatory treatment to the prejudice of your honour or reputation as an artist. And when you're thinking about sort of public art, so say you've got that in a beautiful colour and the council says, I'm going to paint it in anti-graffiti paint and it's going to be this black stuff, or film when they want to colorise black and white versions of things. So it sort of bubbles up in all sorts of different contexts. And it flows into the credits and acknowledgement, which is a sort of, an expression of the moral right to be associated with what you create. So as a creative, look at that. Often each side or different sides to a contract want to be acknowledged. The government will need to be acknowledged about putting money in because we've got to be accountable for public funds, public money. So we've got to say, look, this is where it's come from, isn't that great? So there's a reason why that's there. But often there's other clauses about credits and acknowledgement, and sometimes about if someone wants to have their name off it. There's often two aspects to it that you can look for. Payment, very important for artists. Look at the dollars or look at whatever you're getting in exchange. Remember, this has to be in an agreement. It's an exchange, right? Deed a bit different. Agreement and exchange. Often the exchange is money. So look at that, but also look about installments. Is it tied to milestones? Can you actually meet those milestones? And look at the cash flowing of it. Can you actually do the work with that cash flow? Does that work for you? Because some artwork and some creative work, and say again, films, they're going to film over a certain period. They're going to have to pay people during the shoot. So all of those things are not just theoretical; they're practical. Can you eat while you're doing this work? Have you got that money coming through, or are you just being paid at the end? And then I've got repayment, and so there's the T is floated. But repayment, sometimes you have to pay it back. If you can't complete what you said you've got to complete, it goes back. If you haven't spent it all on what you were going to spend it all, if you spent it on something different to what the other side actually agreed that you could. So again, you've got to have those conversations. If you're going to do that or want to do that, and it's a variation, you've got to be upfront about it and come back and say, look, this is going in a slightly different direction. How do you feel about me doing that? Can we agree that I change? Don't leave it to the last minute and be in danger of having to repay it back because it doesn't fit with what you've agreed.
It's really important as well with our funding agreements is that we do have those opportunities for variation because we know that things change for individuals, for organisations, for projects. If things are fluid, they'll change, and there's opportunity to make variations, and that people shouldn't be scared of that. Like you've done something wrong because something has changed. You haven't. It's just a part of life. And that's where these variations to contracts can help.
Thank you. So next slide.
Oh, sorry.
Okay, so we're nearly getting, because this is quite dense. So this is the sort of final bit of the dense part. So I've got reports and meetings. Often they're required to a certain extent. Often you don't have to come in and physically meet anymore, but just think about who and why and what, and is it too much? Is it going to actually interfere with what you're doing? Does it work practically? You'll often have reports, maybe reports on either side, but people will want to know what's going on, not just at the beginning, at the end, but through a creative process, right? So there's going to have to be some sort of discussions in some way. Delivery, what are you being asked to do? When? where, how are you going to get it there? We talked about that a bit before. And what is it? You know, how much are you being asked to do, and be clear about that. And then risk, we mentioned before too. If you're having to shift things around, if you've got a little team, if you're trying to sub out, you know, who's responsible for. We talk about insurance and risk. So risk, we talk about liability. Are you going to be responsible if something goes wrong, right? If there's sort of dollar figures, if someone gets injured, if in film, if you know something is defamatory and someone can sue, even though you've gone through the script with a fine-tooth comb. So risk comes up in everyday life, of course. So in a business world, it comes up as well. But in life, as in, you know, insuring houses and cars and other things, just like we do there, there's of course business insurance. You know, have you got employees yourself as you grow your business? Are you going to have that and need insurance for that? So often in a contract, there's clauses about we talk about who's bearing the risk. That just means who's responsible, right? If there's an issue, a problem, a liability, who's going to be responsible for it? Can you insure it? You know, does that help you? Often there's things called indemnities. So just be careful of them. Be careful about how broadly it says you might have to promise to indemnify someone. Again, a very old-fashioned word. It really means to reimburse someone, right, if something goes wrong, especially if someone outside the contract has a problem. So say if someone outside says, you've infringed my copyright, you've ripped off my idea, right? So I'm going to sue. And then the other party says, well, that's not my problem, that's your problem. And sometimes they'll stick in indemnity saying, and if it is and they're right, you have to reimburse me. Yeah. So always have a look at that and look at, I'm saying how broad it is. Disputes. What does the contract say about it? Does it give you the right to actually have a talk? Don't run off to court, talk first. If talking doesn't work, can you mediate first? Arbitration is another step up, and then court. Is court the final thing? You know, because remember, court is difficult, hard, emotional, expensive, all of those things. So is there a mechanism or a stepping out so people don't rush off first? Early termination. Can the other side actually bring it all to an end and just say, okay, we've actually changed our mind? And you might be halfway through and we'll give you some money, but that's it. Can you, like, what happens if something happens to you, or are there circumstances when you might want to bring it to an end early, and not just go the whole way that you originally promised? So look at that, and then look at consequences. What happens? Do you have to pay them? Do they have to pay you? Yeah. And when I put the general boilerplate, there's often clauses at the end that are actually called often general or miscellaneous, which I think miscellaneous is misleading. And lawyers and others often call them, oh, they're the boilerplate clauses. The danger in thinking about it that way is that they actually all have meaning. So sometimes there's things in there about subbing out, you know, just hidden away, or it might be the law that applies to the contract. So it could be all sorts of things. It could be, so you'll sort of see them listed. It's often a page, half a page, but read everything. Like you sort of wouldn't hopefully like miss the final chapter in a book, which is the sort of, even though you might have worked out how it ends, if it's a mystery, you'd sort of probably still read it. So still don't dismiss it entirely, because some people get caught. Okay, so that's the sort of last of the really dense slides, I think. So
shall we get to this question from Lisa Hort about how do you protect your concept before the agreement is signed off?
So two things. A lot is confidential information, if it is confidential information, so if it is secret, and you can do that. You could do it in words, but that's dangerous because the person could say, I don't remember that, or remember it differently. Or you have like a letter, a confidentiality letter and someone signs, or an email that just says, I agree, if you agree to that, send it back before you give them a concept or a pitch. And actually the Arts Law Centre used to have, they've probably still got it, some templates that would at least give you a model to work on. So unless the concept, so that's the sort of general idea. Now, some concepts, if you've written it, so if you've recorded it in some way, so writing in a general sense, electronic, if you've recorded it in some way, there may be enough to have copyright in it. So it may be protected by copyright, depending on what it is. But some things like pictures are not, or some things are so insubstantial, a good name or something, that it's actually not, and confidential information comes in, and that's a better way to do it. Some secret sacred information in First Nations context has been protected by confidential information, not copyright, not IP law. Yeah. So what I would do is look at the Arts Law Centre of Australia website and look at the resources on confidential information.
Great. Thank you for that, Sally.
That's
Hopefully that answers your question, Lisa.
Okay, so I'll keep going. We're nearly there for anyone who's wondering whether we're nearly there. We are. So we're coming to the end, which is why we've got contract problems, because hopefully that, we're not going to have them. And we're going to come to contract problems, a contract end, and then tips. So, look on the Arts Law website. Yeah. So when we talk about contract and problems, we're often using the word, or lawyers are often using the word breach of contract. It just means someone hasn't done what they promised to do. So they haven't complied is another way of saying it, but you breach a contract. Now, sometimes the contract will say you get 14 days to fix it up, or 30 days to fix it up. Sometimes they'll say, oh, this is so terrible, no one can fix it. Often there's remedies. So the idea about there's legally enforceable contracts is that a court can enforce them, and that means there's remedies, consequences that can be significant, right? Sometimes it means the other side can actually end the contract, right, and just finish the deal. Sometimes whoever's in the right can get compensation, and that's called damages. So when you hear damages, that's compensation, as if the contract had been performed, as if the right things had happened, right? I've got mitigation. That's starting to get a bit technical. It just means that if someone is actually suffering a loss, they can't make it worse and worse and worse and then say you have to pay everything, right? They can't be so slack, basically. So specific performance is something a court can order sometimes not. In other words, you have to do it. And an injunction is an order to do something or not to do something that a court does. So there's sort of significant things that a court can say, look, the wrong thing has happened. The other side was in the right. So they're entitled to what we call remedies. Yeah. I've got privity at the end with contract problems, and because there's this language, these words that are used that are coming from hundreds of years. Because this is a bargain, the traditional thing is that it's only the people involved in the bargain who are involved, right? Who are responsible. So someone down the road can't go to court and say these people haven't done the right thing, right? So I'm just thinking, unlike like trees being cut down, where you can actually make a complaint and do things in the community and things like that. So the usual rule is, and it's called privity, it just means the parties to the contract are the parties to the contract, and they're responsible, and no one else can come in apart from courts and mediators and things. No one else can actually meddle in it. Now, some countries, have actually made changes to say, certain special people can actually come in, but I think that's getting a bit complicated. That's quite rare. So I just wanted to raise that too, because it goes back to, what is it? It's a deal between people, and it's voluntary, right? And it involves them, and not so much other people. So that's that one. And then the next one, Beck. this is just if a court's going to look at it and how do you read a contract, you actually read it objectively and you basically it's the plain and ordinary meaning. And that's really what I wanted to get at. So read it as a story. You're entitled to understand it. If people are using legalese, and people I mean probably lawyers badly using, then ask them what it means. Yeah. Because a court will think about the plain and ordinary meaning. So apart from you being entitled to understand it, these are good principles. If it's ambiguous, it'll have a business-like interpretation often, not necessarily a legalese, divorced from reality type thing. Sometimes other things will look like circumstances, and sometimes there's special technical meanings of things. But generally, it's, if you read this, if I gave it to Beck and, can she work out what it says? Right? So what is the plain and ordinary meaning of the words? So that's that one. And then the next one, so it's going back to read it. If you don't understand it, ask. You're entitled to know, to be able to understand and read it. So the next one is probably the contract end. Yes, the game over end. So how does the contract end? How does this story finish? Once everyone does everything, it's finished, right? So that's the nicest way to finish. Everyone's happy and goes away and everyone's done everything they're supposed to do. Alternatively, there might be an issue or a change in circumstances, or, there could be a storm or something. So everyone decides, actually, this isn't going to work. And you just agree. You can always agree and say, look, this isn't working, we'll just walk away. So that's fine too. Sometimes, as I said, if there's a serious breach, the other party can actually come in and say, look, that's it. You've done this and I don't want to be part of this anymore. So you've got to act quickly. You can't just sit around and think about it. But then you need to read the contract clauses as well and get advice, really, because there's rules around that. And I'll just leave those two. There's some technical, ways that a contract can end, but we'll leave those. But there were, I suppose, an interesting thing is when COVID came, there were discussions about, well, what does that mean? Do the contract clauses cover COVID or not? Because no one can really control that. But did we actually think about, pandemic in that way? Now, the insurers did. Like, they all have exclusions for pandemics, but people just like doing deals. I was saying just about important deals, but, day-to-day life, not necessarily thinking about pandemics all the time. So
I think
that was a real
often those
question.
clauses, often there will be a clause about force majeure,
Yes.
which I guess which is like an act of God,
Yeah.
which may include pandemics. But I think it's one of those. It's something happening that no party could have predicted to really kind of blow the entire thing up.
Yeah. No, that's right. And then often those force majeure clauses have everything suspended for a while, but not necessarily indefinitely. Often it has a time when, look, we're just going to have to walk away. And then if we come back together again, that's great. Yeah.
Yes.
Yeah. But I just wanted to throw that in because some things are quirky. Some things happen in real life that are not expected, of course, and, cause all sorts of issues. And maybe the contract ends because of that, because of something that no one expected. And then we're up to the final two bits of information, which is wrapping it up and trying to get back to the sign on the dotted line question. So we're doing a loop. The first contract tips is the negative and the next one is the positive. So we're going to end on a positive. So what are the dangers? Over-promising, not being able to do what you say. So just being, thinking about that from the start. Can the other party do what they're saying? Or are they inexperienced? When we talk, and I'm going to use the screen again, like, can that distributor actually understand and know that market in that place, or understand streaming as opposed to analog forms of, are you dealing with the right person at the right time? Giving away more than you need to or more than you want to. And again, check the language. I'll just do another copyright thing is that when we talk about selling copyright, often the word is assign, ASSIGN. Now that's an old-fashioned word again, you don't use it in everyday language. And sometimes I think artists have seen signed things with that word, not understanding that means sell. So, more than you need to think about the language as well as what it is. Bad deals. You've still usually got to do it, because a court will often say, especially if there's a written agreement, they'll say, well, you signed it, right? Sometimes they can do an overlay, but going back to that principle of freedom, and this is a voluntary thing, it's not like you're forced to do it. So bad deals and gaps in deals. So think about those and being caught. And then this thing about the internet samples and templates coming from all over the world. So it may not be appropriate, or the language may be different, right? And I don't mean whether it's English or something else, but terms in the US mean different things because there's different laws. So be careful about that. The heading might seem right, but the content may may not fit with how we do things here. But on the positive side, so Beck, if you can go to the final one, lawyers will always say, write down what you're agreeing to. Even people with the best of intentions can have a different impression or a different ability to remember things. So I'm not just saying people will be manipulative or, deliberately misleading. Write it down, or you may be coming from different perspectives, different backgrounds. Write it down. If you don't have a sort of formal document, and as Beck said, you may not, if you've had conversations, confirm it in an email. Say, this is my understanding. Can you confirm, in a reply email? They may flash out that they do agree, or that they don't, that they'd actually, misunderstood something. So write it, read it. Again, we've talked about it as a story. If you don't understand, ask questions. Research, meaning particularly the other parties, or even like if you're an employee, industry standards. Are there awards? You're supposed to be paid a certain amount. Are there entitlements? So think about that. Question, and I've got negotiate, like that may raise questions, and you may think, actually, this needs to change. This isn't quite right. So think about that. Advice, independent advice is important. So each party should get their own advice. And I've got negotiate there again. That may, throw up some issues. Understand, always important to understand before you sign. So it's only once you've done all of that that you are close to signing on the dotted line. And it is either signing on the dotted line or, and arts law used to tell artists this, that if it's really a bad deal, let's walk away, right? So it's not necessarily sign on the dotted line. Let's think about it. If you're happy, if you do sign on the dotted line, keep a copy for yourself. It will be much harder in the years down the track if you haven't got a copy and things bubble up after the surface, or months after the track. So always keep a copy that you can refer to. So they're the main tips, I'd say, and that's it.
That's fabulous. I think this is really it's so important to think about these things in that situation where you are what feels like a power imbalance between, maybe an important organization that hands you a whopping great contract full of information that you have to spend a long time to understand. But I think knowing that you are a party in this, you're one of two parties in this, or several parties, and you have the right to do all of these things, to read it, to research it, to question things that you don't understand. And it happens a lot. It's not because you're silly, or you don't have a good understanding of law. It's actually sometimes there are issues within contracts that normally people will just sign, and you might actually find something that is incorrect, and not suited, and is a bit of boilerplate that actually isn't suited to the work that you're doing. So it's a really important process to sort of feel empowered to embrace that and look at it. Yeah.
Thanks, Beck. I think that's right, that what you're presented with may not be a fit for you.
Yeah.
So it may be, may have worked for someone else, but it may not fit with how you're going to work together.
Now,
Yeah.
Lisa did have another question about that original question that was about the concept,
Oh,
um,
yes.
asking how do you protect your concept and how do you enforce this if it's breached, is this second question. And I think you did talk through some processes around breach of contract.
Yeah. So it partly depends what you sign, and it partly depends, I suppose, the answer on whether it's confidential information, which is protected at law, um, or whether it's copyright, again protected by law, um, but in a slightly different way. Um, so I'm just thinking how to answer that clearly. So
Mm.
if it's a confidentiality agreement, it's going to be an agreement like anything else.
Mm.
Plus, there's the complication is there's also an equitable thing which I
Mm.
won't go into to protect it. But you would have rights under the agreement if they breach the agreement. Better to have it in writing than not. There've actually been court cases on pictures for television shows that were said to be stolen. I think one was one of the millionaire ones. And, depending on what you can prove, because if it's just conversation, I'm saying just conversations, but again, people remember things differently. It's harder to prove. So better to have it in writing. And then the remedies are what I've said, which is, can be damages for the loss you've suffered. In a copyright sense, they're often a loss of the license fee that you would have got if you'd licensed it, if people had asked for permission, but, can be other ways to work out the loss. In copyright, sometimes people choose, but there's a loss of profits or a loss of like the fee, the license fee.
Mm.
So different, there's different ways to work it out. Sometimes in copyright, there's injunctions, which is stop using something, but you need a
Mm.
court order, right? So go back to the agreement, see what you've agreed, see if there's a dispute clause saying you have to talk about it first before you go rushing off anywhere. If it's caught, that is still a big deal, which costs money. Um, so get advice, I suppose.
Mm.
Arts law, we keep mentioning, is a good place because you don't, if have to pay the commercial law firm fees, and they have lots of volunteers, at least as a start, to get advice. Yeah. So does that help a
Yeah,
bit?
I think that advice, if you've got like a specific contract breach issue that you want to pursue, that you go
Yeah.
to arts law and get some
Yeah.
advice about the
Yeah.
specificity of that. Yeah.
Because it does depend on the actual circumstance. So we can't give you that advice like in this webinar. And lawyers will say you need to look at the actual facts. So lawyers do deal with what exactly happened, what have you got, who was it, when it was, and work through the particular problem. So we can just give you, I suppose that's something we say, we're giving you general information at the moment. Specific information has to be looking at the specifics,
Mm.
which we can't do here.
Yeah.
Yeah.
I think there's Lisa's followed up saying that this is something that happens to artists regularly, where they will have a conversation about their ideas and then they'll find that those have been
Yeah.
taken
Taken.
forward without permission. Yeah.
Yeah, you do have to be careful. That's why I say like get something in writing. So have a look to see if that at least that document is there as a guide. And it does happen. It does happen. There was I know circumstances, I think, where someone's told a friend an idea and then they've carried it out. And copyright doesn't protect a mere idea, right?
Mm.
Copyright protects the way it's expressed. So if it's a mere idea, you're really looking at confidential information or, yeah, secret
Mm.
information. Yeah,
Yeah.
yeah. And that law, and then you have to decide. It gets a bit tricky whether it's under contract, under equitable stuff. So I won't get into all
Mm.
of that. I think it's sort of a bit beyond the talk. Yeah.
Mm.
But that's it does happen, which is why there's court cases on pictures to broadcasters on shows. Yeah.
Definitely.
Saying I made the pitch and you've made the show. Yeah.
Yeah, and I think it's probably back to the original things that you were talking about when you're sort of setting yourself up to have these conversations and agreements, that maybe it's about sort of empowering yourselves as artists and creatives to say, yes, I will have the meeting with you. However, I will do it on these terms. And then you are able to sort of bring some of your own, I guess, agency into the conversation.
Having said that, it does depend. Look, the practicalities are it does depend on bargaining and position. So some organisations will just say, look, I don't deal that way. Some actually say, I don't take unsolicited scripts, or I don't take unsolicited. And it's because they're worried about those acts that someone will then say, oh, well, you've stolen it. So it's sort of working both ways. There can be a nervousness on organisation side to listen to people. Yeah.
Definitely.
Yeah. So it's a tough issue. Yeah.
Yeah. Absolutely. And so we will, when we do post this webinar up on the website, we will provide some links to Arts Law so that you can do some further digging into these issues yourselves. They've got a lot of free and pay for use resources on there too. But I guess I'd just like to thank Sally for a really interesting conversation about contracts. And I've learned a lot, and I've had lots of memories about contracts come back to haunt me as well. Thank you so much for that presentation. It really was illuminating and great.
Thanks, Beck. Thanks, everyone. No, I can't see you. Thank you.
Thanks, everybody.
Thank you.
Okay.
Yeah. Take care.
Bye.